Unsiloed podcast is produced by University FM, elevating the stories of your institution.
Welcome to Unsiloed. This is Greg LeBlanc, and I'm here with Katharina Pistor, who is a professor of comparative law at Columbia Law School and also the author of this book, The Code of Capital: How the Law Creates Wealth and Inequality. Welcome, Katharina.
Thank you for having me.
So this book, I think what this book is trying to do is trying to convince a general audience that what we think of as capitalism, right, relies to a great extent on law. Now, as someone who is a lawyer, it seems in some sense fairly obvious, right, that without these things like contract law, property law, debtor-creditor law, bankruptcy law, and so forth, all my favorite areas of law, right, that nothing that we see in the contemporary economy would be possible or would make sense. In fact, you have this wonderful quote, which is, law is the cloth from which capital is cut. And I really liked that quote. But I guess the question is, who could possibly disagree with this? I know you pointed to rational choice theorists and Marxists and even some of the old institutional economists as failing to recognize the importance of law. And you emphasize that they talk about forces like the invisible hand and they sort of, I know certainly in my field in economics, law is sort of seen as, oh yeah, it's that thing that happens, it's in the background, But I remember how frustrated I was when I was studying economics, which is what motivated me to go and study law. So I guess the question is, why does this battle even need to be fought?
I think it needed to be fought because there's just too much focus on what we see, what I would say are like the symptoms of the capitalist system rather than the root causes. It's like when you think of a doctor who understands the genetic causes of a disease. And of course, you also want to look at the symptoms, and sometimes similar symptoms have different genetic causes and vice versa. And in some ways, I think of the law as sort of the deeper DNA, the genetic code of our capitalist system. And to uncover that and make it visible for a broader audience, as you suggest, was crucial for me. I also think that the general public sometimes has a hard time understanding the difference between, let's say, a piece of land or a house and the property right to the house. And these are two different things. And they can be also then split up in the law in many different kinds of rights and claims to that thing which we see as the house. But property and land is just not the same thing. And once you start abstracting from it, you can also see how we can use these legal devices, the property rights, to do all kinds of other things with it, all the way to our complex financial assets. And I just wanted to make that more apparent and make it subject of a broader debate. Is this what we want? Is this how the law should be used? Why has it been used? That kind of thing.
Yeah, I think you said that law is what enables an asset to become capital. But I would go even further. Law is what enables an asset to exist, right? I can't even imagine it as being an asset if there wasn't some kind of legal protection. It would just be dirt, right?
Yeah, I agree. Yeah, I agree with that. So I'm basically thinking, you'd give me any object, any promise to future pay, or any idea, and then with the right legal coding, I flip it into a capital asset, and I think that captures the core idea of the book.
Yeah, most of the things that we own aren't even things at this point. There's, I think that, I don't know what the number is, but somebody calculated the value of all of the assets in the American economy. And I think the total value of all the assets is something like 7 or 8 times the net value of the assets when you cancel out all of the different claims. That seems to me to be a feature, right? Not a bug. I think of that level of complexity as a thing of wonder, a thing of beauty, right? I think of this empire of law as a magnificent structure that enables the advancement of human civilization, progress, prosperity, and so forth. I think in the book you're emphasizing more sort of the dark side, right? Pointing out some of the problems associated with this complexity.
Yes, and the reason I'm doing this is because I think that's what I observe, and one can have different opinions about what we observe. There is, of course, beauty in it, and I think I would agree with you that without basically abstracting the legal entitlements from the things as such and making them usable also by private actors to code all kinds of things as capital, we certainly wouldn't have had the kind of economic and social development that we have seen. But I also think that this economic development has been rather biased in some ways, right? So the system could give way to flourishing of all lives, of all people, to advance the capabilities of everyone, as Amartya Sen or Martha Nussbaum would put it, if we created the conditions under which people could live the lives they have reason to value. But I do believe that if you look at it historically and also contemporaneously, that you have some agents who have better access to the coding practices and the sophistication of coding, and they can use the law in a way that advances not only their interest, but their wealth. And by condoning that directly or implicitly, the legal system basically allows them to take a social resource, the legal system, for their private interest, while at the same time not offering similar opportunities to others and sometimes actively depriving others of these kind of opportunities.
And I think you suggest some alternative ways to organize the legal infrastructure. But I guess before we get into that, one thing that I think many people will have trouble with is understanding exactly what capital is. So,
Yeah.
in the book, capital sometimes seems like I don't know, an agent, right? It seems like an actor, right?
Yes.
And as this boogeyman. And I was sometimes wondering what you are referring to precisely when you talk about capital as this sort of irresistible force.
Yeah. Let me first maybe just explain what I mean by capital and then why I sometimes even give it agency in the book. So what I mean by capital is an asset that has certain types of legal qualities that give the holder of that asset superior claims to that resource in comparison to everybody else. I'm basically saying what the legal system does, it allows the holder of an asset to have priority rights vis-a-vis others, stronger rights rather than weaker rights. It allows, with sophisticated coding, to pool assets behind a legal veil and ensure that they can incubate over time and grow. That's what I call durability. For financial assets, it goes even further, but basically creates durability by giving the holders a claim to convertibility, to flip their assets that might be in danger of losing value, like in a financial crisis, into a safer asset. Read state money, which maintains its nominal value even in times of crisis. And last but not least, we have actually the state with its coercive powers that stands behind that. So I'm basically saying it's not just, it's not one of the factors of production, like labor and capital are the two factors of production, the standard economics explanation, but it's a particular factor of production that already allocates certain rights to them and ranks these rights in a certain way that gives these holders certain types of rights. So that's the starting point. Now, when I unpack how capital is coded in law, I look at the different legal institutions. One really important one, I think, is also corporate law, which not only creates capital but creates legal entities that act in the economy very much as persons. And I think if you look at the cumulative power of capital and the agency that certainly corporations have, or also agents have through their patent rights over others, sometimes you really have the feeling that these are actors in their own rights that actually can exert power over others, in particular over humans, in a way that might not have been anticipated when we created these institutions, but that's the real effect that we feel and experience today.
Mm-hmm. But it seems like a lot of the conflicts that we see are conflicts within capital, right? As opposed to capital versus non-capital. I mean, you spent a lot of time, I think this book was inspired by the financial crisis, and the financial crisis is one of my favorite topics to, teach. But when we look at something like the collapse of Lehman Brothers, I mean, most of the people who were harmed directly by the collapse of Lehman Brothers were folks who were, I guess we would categorize them as capitalists, right? So whether it was the creditors or the shareholders, right, they lost out, and most of the litigation was just one group of capital holders versus another group of capital holders. When we're thinking about capital, who is capital, who is non-capital, and does it make sense to dig into the kind of distinctions between debtors and creditors and corporations and shareholders?
So I think it does, but it also shifts over time. So I think, let me first make a little comment on Lehman Brothers. I think the fact that the damages were kind of limited to some extent, although I'm not even sure I fully agree on this, but the fact that the fallout from Lehman was limited was because the central bank stepped in and the state stepped in and minimized the fallout, because we could have seen a 1930s scenario. And so if you allow the financial system to self-destroy, which it tends to do because of the way it has been constructed in a highly levered credit-based financial system, it is fragile, inherently fragile, and crashes from time to time. If we allow it to crash, we can have a major social fallout, right? So I think that we should keep in the backs of our mind, and the fact that the central banks intervene and do something is not costless for society. Sort of a different big topic that one could discuss, but I think we should keep this in mind. So in general, how do you think about who are the capital holders? I think you can actually see this over time, and what I found fascinating in Thomas Piketty's book, Capital in the 21st Century, he has a chapter on the metamorphosis of capital. He was basically trying to measure what types of assets construe wealth in different periods of time. So until the end of the 19th century, it was mostly agricultural land. In England, Britain, still until the 19th century, already had industrialization taking off, but it's still rural land that is the most important source of wealth. Why? It's been deeply protected in legal structures that allowed the landowners to basically lever their land, take the cash and put it into commercial enterprises, make money, and then also be protected against creditors, because creditors under the entail, which they used to make sure that nobody could take away their land, creditors could take only 50% of the land and never the family mansion, because they said the creditor is not really an owner, he's just a life tenant for the land. So that's another legal fiction, if you want, but with really real implications. So it was rural land, and then after that it became mostly financial assets. It's shares and bonds, but it's also assets in urban housing, and urban housing is of course also credit financed to a large extent with securitization. We can see that too. So you can see that sort of a lot of private wealth is held in different types of assets over time, and that's actually what fascinated me so much, is that you see the same legal institutions that were first used to code ownership in rural land for the landlords. The same types of mechanisms can be used to create complex derivatives today. And the shift from asset to asset is something that the lawyers can maneuver because they know how to code different assets. It also allows, and this I think is important to recognize, it allows different types of groups to come forward. So it's not necessarily that you have only the aristocracy that wins all the time. You have new folks, sometimes of course they diversify, the aristocrats diversify away in the 19th century and already have financial assets. But you have new types that come along but use the same mechanisms to produce their wealth. So I do think after the end of the 19th century, and I think this is signified by the major legal changes that happened in England again after a major crisis, after a depression in agriculture in the 1870s. After that, you see the rise of new types of institutions, and also new types of constituencies that benefit from these institutions, and you see a very clear shift from the protection of owners to creditors. And I think that signifies also our situation today, is very, very strong protection of creditors, a highly financialized global capitalist system that also needs always the support of the state to make sure that it doesn't crash from time to time.
Yeah, what I find interesting about that story is that there's sort of these trade-offs between the different modules that you talk about, right? And how sometimes in order to strengthen one, you have to weaken another. So in the case of the entail, for instance, you talk about durability and the need to kind of maintain some security and long-term interest. And of course, the entail protected that with the aristocrats. But alienability, right, and convertibility, those are also features. But the only way to kind of get those is to sacrifice some of the durability, right? Because if the entail made it difficult.
Yes, right, or to invent a new institution. Yes, yeah. Sorry. I think you can also, again, with the law, you can have it both ways. You can have the cake and eat it too, because with a corporation, you basically make the assets durable because you say a legal fictional legal entity owns the assets and you allow shareholders to trade the shares. So you can get in and out as a shareholder, and you still can keep the assets together. I think that was the major invention of the business corporation, and I think that was also critical for having capital on that scale. You have sort of you have durability at the same time as you have convertibility, effectively.
Now, you did start off with land, and you talked about the enclosure movement and the conversion of communal rights to individual rights. And this is seen as sort of, I guess, in the interest of capital. But you also reference folks like Hernan de Soto, who were trying to give individual peasants some ownership in their land so that they could get loans and so forth. So to what extent is the story one of creation of private property, and to what extent is it the creation of capital? Are they the same story, or are they different stories?
I think they're parallel. They're not entirely identical, but I think they belong together. I think the idea of capitalism is individual rights holders and asset holders, also individual debtors that can be that are liable for debts that they don't pay, and you can enforce against them. And I think you see Max Weber, the German legal sociologist, has explained this in great depth, that the abstraction of a credit contract from the social embedded relations that pre-existed capitalism was a major shift in the way we organize our economic and social relations. So you have a credit contract that you enforce no matter what, without respect for what the concern of the household is, whether they just lost a job or had a health issue or something like that. A credit contract is abstract from that social relations and can be enforced by the creditors, and if that means bankruptcy or eviction, basically so be it. So in that sense, I think the individual allocation of rights and responsibilities is a critical mechanism for the evolution of capitalism.
Mm-hmm. And you also talk about intellectual property. I mean, that seems to be the fastest growing area of property, right? I mean, I think at one point it was the increase in all of these derivatives and CDOs and so forth, but it seems like the focus now has shifted to the creation of ever more complex intellectual property rights. I mean, is there a point where the creation of new rights will ultimately cause the system to grind to a halt, right? Because, I mean, you can't, at some point when you create these new rights, you are necessarily impeding the capacity to create new rights.
Yes, yes, in principle, yes, and I think that's what Marxists have argued all along and sometimes hoped for, that capitalism would run out of assets, but it doesn't, right? It's beyond even intellectual property rights. We're right now in the age of data. It's basically our social relations that are being commodified and assetized and used for capital creation. Sometimes people call it the new oil, right? So there, I don't see there's an end point, because with the same legal institutions, effectively, you can take all kinds of other things as long as you can capture them. So I think the pattern is always the same. There's some ambiguity about who owns something. Who has a right to that piece of knowledge? Who can actually enclose nature's code to try to create a patent and then make money off selling kits to test whether somebody has the breast cancer gene or something else, right? Who can do that? Can somebody do that? As long as there's ambiguity, some people will try to capture it, get a patent, exploit it for a gain, and even if 20 years later the Supreme Court strikes it down, you make a lot of money on it. And in the meantime, you might also have collected a lot of data, because everybody who uses your kit, and nobody else is allowed to use another one, sends the data to you. Now you have a monopoly over data, and you are the only one who can test effectively for breast cancer. So you could really see how sort of one asset type after the other. So the metamorphosis of capitalism hasn't stopped. It goes from land, it goes to financial assets, it goes to intellectual property rights ideas, it goes to relational data that we have now. We can speculate about what comes next, but I think as the logic of the system says, it has to continue.
So look, the law and economics approach would be the more property rights you create, the more incentives you create to invest in the expansion of wealth. I mean, what's the problem with that argument?
Well, what we see, what we observe de facto is we have actually an increasing inequality in the system, right? So that's the big debate I think that Thomas Piketty, brought about with his book. Is the Kuznets curve correct or not, right? Kuznets predicting in the 1950s that somehow capitalism will equal out, and we have actually this sort of inverted U curve. And he says, at least in that book and in the follow-up, he says that's actually not happening. It's happening only if you have a major crisis and the massive reallocation of wealth that has been created in the meantime. It doesn't naturally peter out. It has to either you have to go in and tax away the wealth and redistribute it, or you have to have a crash of the system for redistribution. And that's sort of at the core of my book as well. Why is that so? And what I'm arguing essentially is if you have resources and you also understand the game, and you have access to really good lawyers, and for that you need resources, you can actually code new types of assets and play at the frontier of the system. And you're not only playing, the sophisticated game that you have learned using your skills within the rules of the game, but by having access to the lawyers and using the private law to code different types of assets and create new rights, you are actually changing the rules of the game as the game is in motion. So just imagine what, baseball, American football, or soccer. While we're playing, the most powerful players can actually change the rules. That changes the role of an umpire, because no longer clear really what the rules are. But there's some, let's say, 800-pound gorillas on the field who actually can change the rules and can benefit from the rules, while at the same time saying, actually, this is legal, because this is what the rules say. And once in a while, of course, that is challenged, whether what they have done is actually legal, and then it's basically a court battle, or 2 or 3. And the more resources you have, the more court battles you are able to fight to ensure that what you have created will be ex post sanctioned by a court as legal.
So the standard antitrust argument is that if we allow the concentration of corporate power, these corporate entities will influence the political system to protect their interests. But you're making the case that they will influence not just the political system, but the legal system, right? And that the legal system is sort of a marketplace where influence can be purchased by getting access to the best lawyers, right? I mean, is that sort of how it works? I mean, whoever has the best lawyer wins?
Yeah. I don't think it's entirely wrong to say that. And if you look at what lawyers are being paid, I think you can get a sense of the kind of value that they're creating, at least if that is a market, and that could also be subject to debate. But, I think in general, I would say we have to realize that we're living with 2 legal systems. One is the public law system with rules and regulations and administrative law and things that are being then passed from time to time in the legislature to also sometimes try to tame the excesses of capitalism. And the other is our private law system. And the private law system by design gives private actors the right and power to organize their relations in a relatively horizontal fashion, using the law, being able to say we have a legally enforceable claim, but doing it on their own. In an ideal world, we do this really in a horizontal relation. You and I, we meet and as equal people outside a polity and just do our transactions. And that sounds really nice, except that in the real world, the relationship between me and you are not equal. Not by resources, not by access to lawyers, not by the ability to use a legal system or pick and choose my legal system to be able to structure the relations in a particular way. And to the extent we condone that and don't second guess it or sometimes put a stop to it, we allow basically people to create their own legal system. When you talk to the lawyers who were involved in creating these master agreements for the international swaps and derivatives, they call this private legislation. They create an entire system of contract law which supports a global system of trading financial assets, right? That then crashes at some point, but it did support it. And it's fascinating. Again, it goes back to the beauty of what you can do with law. But it's still one-sided and biased. There are lots of people who don't have rights. There are lots of people who can't go to court. And not only because they don't have resources, because they're also being forced in standard contracts to sign off that they have only arbitration and they can't go directly to court. So there is a structural bias, I think.
So if law is the cloth from which the capital is cut, these lawyers are the tailors. And I find it fascinating that the only way this can work really is through a particular mix of decentralization and centralization, right? Because, in some sense, everything is highly decentralized. You've got these incorporations that happen in all these different jurisdictions. You've got, choice of law where people can incorporate under, Swiss law with adjudication in London, right? And yet the only way that decentralization could lead to this innovation is if there is sort of a universal respect for the stuff that originates in one part of the system. So the conflicts of laws, rules. So how exactly does that work? I mean, if it was too decentralized, then nothing that happened in Delaware would be recognized in California. If it was too centralized, then there would be one place where everything has to happen, and that would presumably slow things down. So how have we gotten to this point where we have this unique mix of centralization and decentralization?
Yeah, it's a really good
commercial law?
question. Yeah, no, I think it's a really good question. It's also something that few lay people know about, is these conflict of law rules, right? And we always have had them to some extent. So if you go to the era prior to the nation states, when long distance traders would go to centralized market fairs, to Antwerp or to Leipzig or to some of these places, typically all the transactions that were done in that market would be governed by local rule. That also made sense because you had lawyers there and you had judges there. They knew these laws, and they would say, except if there were traders from the same origin, they could say, could we just do our own disputes with one another under our own law? And typically they got a privilege to do so. So that's one way to do this. Then when the nation states came about, they of course disrupted the system and said, we want to consolidate our control within our territory. So our law governs in our territory. But yes, for contracts, we allow some people to do something else. So for contracts, you can opt out and you can say, at least if you can show some connection to that place, we want to have Swiss law because it's neutral, even though, I'm German, you're American, but we do Swiss law, it's fine. And most legal systems allow this. I should add that conflict of law rules are part of the domestic legal system of individual countries, but there have also been made attempts to create standardized principles, to have international treaties or soft law that says this is how we want to standardize this. So over time, people were pushing for more flexibility. And I think the playground for this was really the United States. Because in the US, it's really interesting. It's a federal system that is highly decentralized. At least that's how it started out. Every state has its own private law, its own property law, its own contract law, its own tort law, right, etc. Family, everything is state law. But then, of course, the problem is, as you suggest, if you then move from New Jersey to New York, will the corporation lose its status as a corporation because it's not a New York corporation, it's a New Jersey corporation, or it's a Delaware corporation for that matter. And so in the US in the 19th century, the argument was made that the Commerce Clause of the Constitution basically says when it comes to commerce, because we're a national market, one state cannot deny the legal status of a neighboring state. And so that has then given rise, of course, to shopping for law. Right? So who gives me the best corporate law? And then, of course, you have to ask who makes the decision where to incorporate. It's typically the promoters of the company, the managers, perhaps the shareholders. And so there was a competition among states to create a law that would attract most corporations. And as we all know, Delaware, a small little state, completely agricultural state, without labor unions, without major political movements, lo and behold, wrote the law that most corporations liked for themselves, and so they all went to Delaware and then got stuck because then you get network effects, and so they stay. But so that's how the shopping of law happens within a legal system, where you basically say we want to have some decentralization, but then we make that law portable, and by making it portable, it actually becomes a monopoly, almost a monopoly, not legally, because legally you can still go somewhere else, but de facto, because if everybody is there, then you go there as well. And you see similar phenomena in contract law or in even bankruptcy law, where some courts sometimes sort of pop up as the one where everybody wants to be, and then you internationalize it. Then the corporations in the United States say we want to also play in other territories. And the question is, do these countries deny us access? You saw the same issue within the European Union. And Germany was one of the countries that said for a very long time, if you do business in Germany, you play here, it's our rules. And then the European Court of Justice said, sorry, within the European Union, free mobility of capital and persons, you have to accept the legal persons from neighboring countries. And so we find ourselves in a situation where for commerce and investment, we recognize all legal persons around the world. The only persons that we exclude are humans. So that's where we allow centralization.
Yeah, so while the law creates markets, we have a market for laws, right? In
Correct.
the commercial space. Yeah.
Correct.
And now, I think probably the best law class I ever took was one with Paul Carrington at Duke, and it was a course on international civil litigation and about conflicts. And it seems like, this whole area of law is one that is so essential and so integral. But it seems like it's at least within legal education, it's kind of a backwater. But once you get into practice, it becomes absolutely critical.
Yeah, I think it's a stepchild in legal education, unfortunately. Or if it's done, it's very often also done, certainly in continental Europe, in a very dogmatic and doctrinal fashion. But the implications for global capitalism are quite profound, and I think that is sort of underestimated. There's some experts, I think, that have played in that era, but we don't even have a major course in conflict of law at the law school. We just do it as a sideshow for corporate law or some others. And in international litigation, of course, it will play a role, but otherwise not.
Well, another area of law is comparative law. Comparative law is also one that's kind of a stepchild too, right? You teach it, but I don't think, it's certainly not mandatory for law students to learn comparative law.
Yeah, I think this is really a phenomenon that is typical to the United States because it's a continental state, and so here doing comparative law, people shrug their shoulders. Why should I? This is a big legal system to deal with. It's also already very complicated. Plus, many people also believe for a very long time that most other countries would eventually, at least, converge on the American legal system. In part because of the economic superpower status, right? So the largest corporations, they do acquisitions overseas. Capital markets lead to convergence. That was the big argument made at least until 20 years ago. And whether true or not, we can debate. In Europe, of course, it's very different. In the EU, comparative law is a standard way of trying to find ways to harmonize law, to write new directives and regulations that would be passable in all the member states, right? So it's just almost mandatory to do so. What I always tell my students, and which is why I call myself a professor of comparative law, I got that title, and I'm also teaching law and development, not maybe comparative law in the old sense proper, but I do a lot of comparisons even in my straight corporations class. I always tell my students that we produce here in the United States thousands and thousands of Masters of Law students who go back and practice in their home countries, also in international firms. They know exactly how you tick, because even after a year of American legal education, they at least get the logic of the system. You have no clue how they tick. Right. So I think it's a comparative disadvantage to not understanding where they come from. And years ago, I co-taught a class which we called Lawyering Across Multiple Legal Orders for 1Ls, and tried to teach them how to ask questions about different legal systems, saying, we don't want you to make you bilingual or multilingual. That's too tall an order. But what we want to teach you is that different legal systems have a very different grammatical structure. And knowing that, I think, gives you a comparative advantage over other lawyers in these kind of transactions, in international arbitration. Just why is this argument being made? Why are they prioritizing this strategy over another? That has something to do with the different logic of other legal systems.
Yeah, but it seems like just like Americans and Brits don't feel the need to learn other languages than English. At some sense, the same thing is happening with law. New York law, Delaware law, London law. It seems like they're colonizing the world. The British Empire might be dead, right? Yeah. But it does seem like common law and its offshoots are really taking over the world. Is it an irresistible force that because of the choice of laws?
So I think it's very powerful, and I make that argument also in the book because I faced, of course, the challenge when I say capital is coded in law, and I name the law, and it's actually domestic private law. We don't have a global private law. And we don't have a global state either that could enforce it. So the question could be, how can global capitalism exist without that global law? And what I'm basically saying, global capitalism can exist with only one, in theory, with only one legal system, as long as all other legal systems are willing to respect the rules that are made and enforce them in their own courts. That's what the conflict of law rules do. And I would say, and I agree with you, we have basically two. It's the US and the UK that are at the top of the system, and most globally traded assets are coded in one of these two jurisdictions. There's, of course, a lot of domestic stuff still happening that doesn't see any relationship to global to American or common law. So there's a lot of civil law that still is practiced. But I think the courts in countries in continental Europe, they do see that most of the big international business transactions are shifted into arbitration. They see them only at the back end when they have to execute an arbitral award. So the courts are doing mostly, smaller stuff these days. So yes, I think it's a powerful force, but it's a combination. It's not a force of nature. It's a combination of the choices that we've made to give so much private autonomy to individuals to pick and choose the legal systems by which they wish to be governed, to push through attempts by states saying, actually, I think on our territory, we think we should set the rules of the game, not you, right? That's sort of the constant tension. And I would argue we've gone too far. Because if so many people can opt out of our legal system and yet still be around and do their business here. So if, I think the hypothetical is, if every one of us, every member of society is picked and chose the law by which she or he wishes to be governed, obviously we couldn't have a common polity. Doesn't work. So the question is, how far do you want to push it? And I'm not saying we should close the borders or you can't choose at all, but I think we have also excessively pushed the argument for private autonomy.
Well, it kind of reminds me in the Middle Ages, right? There were clerical courts, and then, and if you were a priest, you'd be like, no, I'm going into the clerical courts, right? You got to try me over there. It's confusing, right? When there's one person injures another, and the identity of the person is going to determine sort of, which venue you wind up in, right?
I agree. And I think we have created something similar. It's maybe not only status, but it's certainly wealth and ability to find the legal system that works and to find multiple legal systems that work in conjunction in such a way to advance my interests. And of course, that's not worth it for some similar stuff, right? Most of us don't have the resources and don't think it's worth it, but some do, and I think it's fundamentally undemocratic.
Mm-hmm. Well, there's another feature, which it's not simply that there are all of these different jurisdictions, and we can choose our jurisdiction. But there's this other aspect, which is that a lot of the legal rules originate in the private sector and then are adopted, right, as formal law. And this goes back, as long as you can go in English common law, right, with law merchant and so forth, where the private parties would kind of devise these ways of interacting, and then they became legally enforceable and backed by the state. And so we see that today, right? The ISDA, right, devises these rules, and then at some point they wind up in courts, and the courts have to adopt them. I remember when I taught law and economics for many years, I'd always start off with Pearson versus Post, right, and a couple of these other old cases where the judges were trying to figure out, well, what's the custom? What are these people when there's no courts anywhere to be found? What do they ultimately agree on? It seems like that's a wonderful way to do innovation. You kind of outsource the innovation, and then you do an acquisition. Like it's kind of like Google. They let some startup figure out some new solution, and then they just come in and acquire it. Right? Is that how the law evolves? And is there a problem with that? Should
So I think what we need to pay attention to is, who are the beneficiaries of the system and who might be the losers. So if we were all the same with the same resources and we could all sort of innovate these rules and, one time you win, another one I win, I think it's just a nice system. We go to court, there's some kind of an umpire that says, I think you're right because of the the principles that I have, I'm paying respect to all principles. At the same time, I see your innovation, and I think this is supported by the law. And here we go. Now we have a new legal principles, and then we can continue to innovate. It is kind of a nice thing, but it's of course a nice thing for the insiders, and it works as long as these transactions don't have externalities. Yeah, so the question is, do they, right? And what are the externalities, and when does this become a problem? And the other thing is that I would also want to highlight, under our civil procedure rules, not everybody has access to the courts. Not everybody has a justiciable interest. Who does or who does not, who has standing in a court of law, determines already who can bring a case to court. So there was this wonderful debate in the 1970s about the efficiency of the common law, right? And I think that was the literature you were just referring to. So if you just litigate and relitigate, the best rules will become about. But I think even at that time, people pushed back and said, but this is not randomly selected, which rules will be, even sort of can be litigated. There are other conditions that have to be in place. So I think if we were able to completely reverse those or, change those conditions to make sure that everybody has access to the courts. I mean, remember how long women couldn't litigate for their own rights, or black people couldn't litigate for their own rights. And now that has changed, but there's still certain interests that you can't bring. Typically individual rights have a better chance than collective rights. And, and so there are lots of, if we just could change all this, and you can make your own rules, and there's some umpires that sort of sometimes create a balance between this, then I think we would be in a different world. But that's not the world we have.
So with Pearson versus Post, I remember the way I would teach the cases, everyone would say, yeah, this sounds great. And then they realize that the customs were the customs of the landed gentry, right? The folks with the horses who were chasing after the foxes, and the people who were,
exactly.
Sort of hunting on foot. Their interests and opinions were excluded from the conversation, right?
Yeah.
Yeah. So you offer a couple proposals for maybe rethinking the process, and one of them had to do with the role of lawyers, and you said that the way when people come out of law school, they are more or less forced by economic interest to join the party, so to speak, right, and become commercial lawyers. Is there? I mean, what would be the alternative? How would we channel legal? Lawyers are among the smartest people that we have in our country, and it seems like their mental energy is devoted to creating ever more granular forms of property rights. Is there a better way to utilize their intellectual assets?
Well, I think at least we could be a bit more diverse in how we spend our intellectual resources. There are, lots and lots of problems that societies have to solve, from inequality to the fallout from climate change. So the lawyers won't do the science, but the lawyers have a lot to do with sort of who bears the responsibility, whose liability is limited, if not completely ruled out. So, there are lots and lots of areas, I think, where lawyers could be very productive. I think you see very few big law firms on, let's say, in my view, the right side of the climate change debate there, because where the money is you defend brown assets, for example. I think some big firms do a wonderful job in pro bono, but it's of course just a small little portfolio. But they do realize that there are many other issues that require legal expertise. That's why they pick up that practice as well. So I think in an ideal world, lawyers would have the opportunity to choose different areas where they are effective. It could be labor law. It could be new forms of business organizations. It doesn't have to be the corporations. There's a lot of happening. People want to have different types of organizations to do not a startup that makes them millionaires, but maybe a startup that allows them to have a decent life and produce the kind of things that they want to produce. And I would want to give them that chance. But for lawyers graduating from top schools like ours, that's not really an opportunity given also the fees that we charge, right? So it's a system that is reproducing itself because the top private law schools are charging fees that ensure that lawyers have to first of all get credits to be able to pay, and then pay down their credits, and that sort of keeps them in the machine of coding law at least for the first 5 to 10 years of their lives. I should add, however, that in Germany, where you still have free education in law schools, of course the top of the crop also goes to the global law firms, because that's the incentives of making that type of money is there as well.
But I mean, can't we just utilize this incredible sophisticated machinery to pursue those goals that you discuss? I mean, if you think about, right, climate change, for the last couple of years, I've been going to Austria to teach a course on sustainable forestry. And what we've seen is that the forest management companies, they've gone from thinking about how to maximize their returns by cutting down trees to thinking about how they can maximize their returns by not cutting down trees, right? Because we've got these new transferable rights that essentially represent carbon that is sequestered in forests. I mean, it seems like the same technology, tradable carbon emission rights and, carbon capture certification and so forth. I mean, those are new forms of property rights that leverage the sophisticated trading technology and so forth, but that are in the service of some of these other social goals that you're discussing. I mean, is it better to kind of harness this technology, or is it better to sort of think about more centralized legislative ways to manage these problems?
So I'm not a great fan of major centralization. I do think that we have to, enable people to make choices themselves on a much larger scale, and I like a kind of decentralized organization. I also think that all forms of power should be held to account, but both public and private power. So I think, in the Code of Capital, I'm trying to make the argument is that private power has grown to a large extent with the help of our legal system that I think we have to seriously try to hold to account and maybe curtail. Having said that, I think in all of these decisions that we're making, I think we have to also think about how to balance competing interest. So there are also two sides, of course, to the carbon offset assets, and the other side might be peasants who, because of the money, will make that deal and that can then get an indefinite lien on their land, which they can no longer use for the ways they would have done otherwise. They also cannot do something that many of them believe is much more important than just sequestering, which is healing the land. So the fact, of course, is that land has been exploited for centuries by our form of agriculture production, and that healing the land would require something very different than just sort of keeping it in a certain way that we can check the box to have a carbon offset. So I think there are also, I think, tensions in that space too, where I think also lawyers would be well placed to think about how to balance these different interests, because to some extent you could also characterize that space as one way we have a new asset class. We don't know yet whether it really works. I've seen some articles in Science that have question marks about how effective the carbon offset really is, whether it's promising too much, but certainly the financial sector and the intermediaries are making money on it. It's not clear that the owners of the forest or the land or even climate as such are the beneficiaries. But, just talking about these things tells you how complicated they are, and it would be nice to have a more diverse debate and also lawyers on both sides having a sophisticated argument about what could be done to maybe have a win-win for both sides.
Now, there's one chapter in the book where you discuss the whole code is law debate, right? And there are people who are contemplating a world without courts, one where they can enter into these self-executing contracts that don't require the mechanism of legal enforcement. Yeah. Now, of course, whenever there's a problem, they call lawyers first thing, right? So, like with the whole, we look at the DAOs, and it's impossible to avoid the law completely. But do these new forms of technologies and these new approaches, which are attempting to get around the law, does this represent some kind of new way of undermining the Code of Capital, or does it seem like an even more extreme version of privatizing these relationships?
Yeah, I think that chapter in my book is probably the one that dates the fastest because of the development that we're observing. So when I wrote the book, I still thought that probably the legal code will come out on top. But I also am, of course, aware of the fact that many more areas of our lives are being controlled by digital code. And so the digital coders are playing a very similar role as the legal coders, right? To what kind of information is being played out on your feeds, in your whatever it's, whether you Twitter, X, or Facebook, whatever you're using, is beyond your control. I mean, you just sign up and then you sign something, and we still pretend that this is a voluntary, consent-based contract. On the basis of that, they can write whatever algorithms and change the rules as they go along, because you're just being notified. And we always click agree, knowing, of course, that nobody can read all of these contracts that we are agreeing to. So I think it's a perversion of this whole idea that this is something that we negotiate and do voluntarily, and there is massive coding of our social relations happening beyond our control that I find deeply, deeply worrisome. And that has a different scale even as the Code of Capital. I think the Code of Capital is really about the use of a social resource, our legal system, with the coercive powers of the state backing that for private gain. That's bad enough. I think the digital code and in the spaces that we're seeing it advancing very fast, to social media, AI, etc. right now, is basically capture of our social relations and the manipulation of these social relations in a way that we sometimes can't even be fully aware of it, and are being subject to a machine. I'm not even saying there's a human up there that controls this, but it's a machine that controls this because, of course, the algorithms are written in such a way that they produce gain, not other types of values. And so, I think it's deeply worrying. So I think there could be a digital code that doesn't do everything that the law has done, and has some shortcomings still, but it's also learning. I think with self-learning capacities, the problem of being unable to foresee the future is sort of not, it doesn't go away, but it is minimized to some extent. So I see the potential in a kind of different light today, I would say.
Well, but doesn't the common law have the capacity to self-correct, right? So, somebody could presumably litigate, and these contracts could be seen as contracts of adhesion, and then the whole thing could kind of fall apart.
Yes.
I mean, what do we think that the common law has lost its capacity to keep these sorts of things in check? Has the common law been captured, so to speak?
So I think in theory we can still use it. But I think it's not wrong to say also it has been captured to some extent. And I think that's, of course, part of this cognitive world in which lawyers grow up, and the judges that are being recruited from the bar have immersed themselves, right? So if as long as you basically idealize formal equality in the law and formal consent as the only conditions for which that we need to subject yourself to powerful actors in the digital space, then this can continue. And I think the self-awareness of the common law to do something different, you see signs it's happening. I think, for example, these two cases against shell corporations in the UK and the Netherlands, where they use the good old duty of care to say a parent company is responsible for its offspring in Nigeria, and it's just the duty of care. They didn't even do piercing the corporate veil, a simple old doctrine. So I think that gives me hope, because I think, yes, there are things actually that one could mobilize. You just have to think about the strategy that is most effective to recode these relations, including digital relations. The other thing that gives me hope in the digital space is that most of the data that are currently being stored, or have been collected over the last 3 years, about 90%, and the same has been true for the last 30 years. That means if we find a way to stop the concentration of data in the hands of the few, which requires both new technology and I think legal protection, we might actually change the system. The question is, of course, it's also a question not only about structuring and design, it's also the willingness of individuals to say, I'm just going off. I'm just switching into a different system where I have more control. And to get that is a psychological issue, and that, of course, is largely in the hands of the coders today, whether they will do this or not.
So of all the various reforms that you propose, which ones can lawyers embrace? Does this require that lawyers become more creative when looking for solutions, or is it that they need to learn more about spillover effects, consequences, and implications of the laws that are being devised, and the mechanisms and the organizational forms and the assets that are being generated?
Yeah, I think it's the latter. I think sort of the single-minded focus on, we've called it efficiency for a long time. I'm not even sure it meets the classic standards of efficiency, certainly not Pareto and however else you want to define efficiency, but basically maximizing returns for your client, that's sort of the overarching goal. The way I teach, and of course I know it's naive because I know the workplace in which the lawyers end up, but I'm trying to push for the thinking about the broader social implications, the trade-offs, the externalities, and how this could be, already captured by the way we think about how to design a transaction up front, or how we even set up a contract for people who have a certain type of interest. Anyway, so I think that's where I would want to go, is just to have a broader mind and thinking about other concerns. Not just value extraction.
So it would fall into professional responsibility, I guess, right? Strengthening.
No, I think it's how you teach each and every class. I mean, when you look into the textbook, I think that it's now changing a little bit. I think even hardcore corporate lawyers, would do a bit of ESG, environment, social, and governance, even though there's so much political pushback against it. But I think there's a recognition that maybe this shareholder value maximization has been pushed a bit too far, even in the academy. But I think it's really within the individual fields. And when you look at case law, and when you look at especially older case law, there's a lot of material that we could harness to say, actually, there's a bit more space for balancing here.
Well, Katharina, thank you so much for joining me. The book is called The Code of Capital, How the Law Creates Wealth and Inequality. We'll talk again.
Thank you.
Unsiloed podcast is produced by University FM, elevating the stories of your institution.